On the first day of January 2026, the tax environment for American homeowners changed permanently. The federal protections you depended on for many years disappeared entirely. The limits placed on state and local tax deductions under 26 U.S. Code, Section 164, fundamentally altered the financial equation for every homeowner who has crossed the age of 60. But the deepest financial wound is not being inflicted at the Internal Revenue Service headquarters in Washington. It is being inflicted right now at your local county property appraisal office. If your birth year falls before 1964, you are currently standing directly on top of a financial earthquake zone. Local property taxes are silently gutting the retirement security of everyday Americans. There is a strong likelihood you are currently writing checks for thousands of dollars in property taxes that the law does not actually require you to pay. Your state wants those payments. Your county depends on collecting them to finance local government initiatives, but the law erects an absolute wall of protection for those who know precisely where to find it. A single document can halt that financial bleeding tonight. Back in 1979, rampant inflation tore through the American economy with destructive force. Property values climbed sharply across every region of the country. Retired citizens living on fixed pension checks suddenly received local tax bills that exceeded their entire year of Social Security income. State lawmakers grew alarmed. Elected officials confronted a full-scale uprising from furious homeowners who were being priced out of homes they had owned for many decades. State governments responded by drafting emergency legislation to shield older Americans from having their homes seized by local tax collectors. Texas enacted Tax Code Section 11.26. Washington State drafted the precise parameters contained in RCW 8.4.36.381. New York passed Real Property Tax Law Section 467. These intricate laws constructed an invisible and impenetrable barrier around qualifying properties. They were specifically engineered to lock your tax burden in place on the very day you reached a certain qualifying age. But the legislators who authored those protections made a critical and deeply damaging choice. They decided the government would never activate these essential protections on your behalf automatically. They decided the burden of requesting them would fall entirely on you. The rules remain anchored to the late 1970s, while your property value reflects the brutal economic reality of 2026. Examine the specific historical comparisons carefully. A conventional 4-bedroom residential home that sold for $45,000 back in 1985 now routinely receives appraisal values of $650,000 or higher. The local county applies its tax rate aggressively against that modern valuation. Your retirement income still bears a close resemblance to what it looked like in 1985. Social Security cost of living adjustments never came close to keeping pace with aggressive increases in local real estate assessments. The enormous gap between the paper value of your home and the actual cash sitting inside your bank account is precisely where the government reaches in and removes your accumulated wealth. The county appraisal office never sends you a courteous warning notice. The county tax assessor never appears at your front door to inform you that you legally qualify for a complete freeze on your school district taxes. They simply determine the highest legally permissible amount, generate the bill, and wait patiently for your check to arrive. They expect full payment because they understand you are terrified of losing your property. The entire system is deliberately constructed to function in absolute silence. They place enormous bets on your complete lack of knowledge regarding the precise legal statutes. This quiet, bureaucratic machinery tears families apart during their most vulnerable and painful moments. The state prevails every single time you choose to do nothing. Margaret lives in a single-story brick ranch home in Collin County, Texas. She and her husband Arthur purchased the property during the summer of 1993 for exactly $145,000. The home sits on a quarter-acre of residential land near a well-regarded middle school. Arthur spent 35 years working as a regional logistics manager for a commercial transportation company. Margaret dedicated her professional life to teaching third grade at the neighborhood elementary school. For 30 uninterrupted years, they submitted their mortgage payment on time without a single exception. The bank finally mailed them the title release in the spring of 2023. Arthur managed every piece of financial paperwork the household generated. He maintained carefully organized tax records inside a gray metal filing cabinet in his modest home study. Arthur suffered a sudden and catastrophic cardiac event in February of 2025 and did not survive. He was 68 years old. Margaret was 64. Margaret spent the following 6 grueling months working through complicated county probate proceedings. She transferred each utility account into her own name. She completed Arthur's final federal income tax filing alongside an accountant. She closed his personal bank accounts and combined their modest remaining finances. She completed every task the probate attorney directed her to complete. She believed she had fully secured her financial standing. Then in October of 2025, the Collin County Central Appraisal District mailed the annual property tax statement. Margaret opened the envelope while sitting completely alone at her kitchen table. She anticipated owing roughly $3,200 and had exactly $4,000 set aside to cover that cost. The figure printed in bold black lettering at the bottom of the page was $9,450. Margaret set the paper down. Her hands were visibly shaking. The county had essentially tripled her annual property tax obligation overnight. She contacted the appraisal district the very next morning and waited on hold for 45 minutes. A weary clerk eventually picked up the call. Margaret described her desperate circumstances. She disclosed that her husband had recently passed away and that her only income consisted of a fixed teacher's pension and a modest Social Security survivor benefit. The clerk pulled her account information and explained the legal situation with cold precision. Arthur had turned 65 in 2022 and proactively submitted Form 50-114, which legally froze their school district taxes under Texas Tax Code Section 11.26. That freeze held their school tax obligation securely in place. However, the exemption carried Arthur's name as the lead applicant. When Arthur died, the county removed his name from the deed. The automated software immediately erased the tax freeze and reset the property value to the current market rate of $680,000. Margaret was only 64 and did not independently qualify for the senior exemption yet. The county systematically dismantled the invisible financial shield Arthur had built and handed Margaret a bill consuming 3 full months of her annual retirement income. Margaret came very close to selling the home she had occupied for 3 decades. She nearly called a local real estate agent that same week simply to escape the suffocating weight of the unexpected obligation. She did not understand how the law functioned beneath the surface. She only knew she absolutely could not produce a check for $9,000. This tragedy plays out for thousands of grieving widows and widowers across this country every single year. The state counts heavily on your grief. It depends on your deep disorientation during a traumatic period of loss. It relies on the statistical likelihood that you will quietly drain your savings account and pay the bill because you fear the government taking your home. We must expose the precise mechanics of how these rules actually operate. Texas Tax Code Section 11.13 subsection C establishes the standard residential homestead exemption for adults aged 65 or older. It legally compels school districts to apply an additional $10,000 reduction to the assessed value of your home. But the true financial fortress is located within Texas Tax Code Section 11.26, which legally creates the permanent school tax ceiling. School district taxes account for more than 50% of the total property tax obligation in most Texas jurisdictions. The moment you turn 65 and apply, the state locks your school tax dollar amount permanently. That number cannot increase. If the school district raises its tax rate to finance a new athletic facility, your personal bill stays exactly the same. If your home doubles in market value, your bill stays exactly the same. But the law enforces strict qualifying conditions. You must occupy the home as your primary legal residence, hold a recognized ownership interest in the property, and physically submit the required application paperwork directly to the chief appraiser of your county. People fail to secure this critical protection for three very specific and recurring reasons. First, they assume the county already knows their date of birth and will apply the exemption automatically. The county has your driver's license information on file, but will never act until you formally request the protection in writing. Second, many homeowners place their property into a revocable living trust to avoid probate and then fail entirely to update exemption records. If the trust document does not include the specific language required by Texas Tax Code, Section 11.13, subsection J, you forfeit the protection immediately. You must demonstrate the present legal right to occupy the property for life. Third, people fall into the deadly surviving spouse trap. This is the identical trap that nearly destroyed Margaret financially. The law contains a specific hidden provision buried deep within Texas Tax Code, Section 11.26, subsection 1. When a spouse passes away while legally benefiting from the over 65 school tax ceiling, the surviving spouse can permanently inherit that same ceiling and keep the frozen tax bill. But the surviving spouse must have been at least 55 years old on the precise date of death, must continue residing in the home as their primary address, and must proactively notify the county assessor to transfer the exemption into their own name. Margaret was 64. She easily cleared the 55-year age requirement, but the county clerk offered none of that crucial information voluntarily. The clerk simply read the balance owed over the telephone and nothing more. Margaret had to independently discover Form 50-114, locate the designated checkbox for a surviving spouse, and submit Arthur's certified death certificate directly to the appraisal district. The precise moment she filed that completed form, the county retroactively restored the tax freeze. The devastating $9,450 bill evaporated from the system entirely. The original $3,200 obligation reappeared in its place. That outcome represents the profound difference between knowing the precise language of the law and being a powerless victim of the state revenue collection machinery. Let me walk you through the exact mathematics of this protection. My name is Walter Barron. I devoted my entire career to watching the enormous machinery of the system extract generational wealth from honest people who simply lacked knowledge of the bureaucratic rules. I refuse to allow that machinery to extract wealth from you. Consider a typical home in a growing American suburb carrying an official assessed value of exactly $500,000. The local school district applies a base tax rate of $1.20 per $100 of assessed value. The county, city council, and community college district combine to add another $1.00 per $100. The total combined rate is $2.20 per $100. Without any legally secured exemptions in place, the annual property tax obligation reaches exactly $11,000. The homeowner turns 65 and files the proper paperwork with the county chief appraiser. The state mandates a significant reduction in the assessed value used for school tax purposes. The school district tax bill drops immediately to exactly $4,800. The state then locks that $4,800 figure permanently in place as a hard legal ceiling. 5 years pass. The neighborhood becomes highly desirable, and the county raises the assessed market value to $800,000. The neighbor next door is 60 years old and does not qualify for the freeze. They pay the full 2.20 rate on the $800,000 assessment and owe $17,600. The protected homeowner's school tax remains permanently anchored at $4,800. Their total annual bill may creep slightly to around $8,000 due to minor county rate changes. The homeowner with the freeze saves nearly $10,000 in a single year. Over a standard 10-year retirement horizon, that represents exactly $100,000 in preserved liquid wealth remaining in their possession rather than being transferred to the government. Now observe what happens when a homeowner misses the legal window entirely. The same $800,000 home, The homeowner turns 65 but neglects to submit the required application. The county bills the full $17,600. 3 painful years later, the homeowner recognizes the error and quickly files the correct form. The county approves the freeze but calculates it against the current elevated valuation, not the original $500,000 baseline. The school tax is now frozen at a permanently higher level. That favorable historical baseline is gone forever. No attorney can approach the county and request a freeze calculated on what your home was worth 3 years ago. The freeze takes legal effect only in the specific tax year the application was formally filed and accepted. This precise mathematical reality determines whether you eat quality meals or stretch every food dollar in your late 70s. It determines whether you comfortably afford life-saving prescriptions or divide your pills in half to make each bottle last. You are currently transferring money to the local government that belongs inside your own accounts. This aggressive financial extraction operates silently in every jurisdiction across the country. Washington State addresses the identical problem through a different legislative approach under RCW 84.36.381, providing a powerful exemption from excess property taxes for residents aged 61 or older. Eligibility connects directly to combined disposable household income. If total income falls beneath a designated threshold, the state freezes your home's assessed value and eliminates entire categories of costly local levies. But exactly like Texas, you must voluntarily file a formal claim with your local county assessor, verify your age, and document your income. If you take no action, Washington State assesses your property at maximum market value and bills you without hesitation. New York State operates under Real Property Tax Law Section 467. Local governments hold the authority to reduce the taxable assessed value of senior-owned residential property by as much as 50%. Read that carefully. 50% of your property tax burden has the potential to simply disappear. You must be at least 65 years old and satisfy locally established income thresholds. But New York builds in a thoughtful sliding scale. Even if your income slightly exceeds the strict upper limit, you may still qualify for a 20% or 10% structural reduction. Millions of New York seniors miss this sliding scale provision entirely. They glance at the published maximum income threshold, incorrectly assume they earn too much, and voluntarily walk away from meaningful financial protection. The state pockets the extra revenue without making a sound. California operates a treacherous framework under Revenue and Taxation Code Section 69.5, substantially restructured by Proposition 19. Homeowners aged 55 or older may carry their existing low property tax base over to a replacement home, but if you fail to submit Form BOE-19-P within the precise legal filing window, the county immediately reassesses the replacement home at current market value. The tax bill can multiply dramatically overnight. The law provides absolutely no accommodation for missed deadlines. This pattern repeats across the nation consistently. State legislators proudly draft protective statutes as campaign promises during competitive election cycles. They issue enthusiastic press releases celebrating their dedication to protecting senior citizens on fixed incomes. Then they instruct local tax assessors to make the actual application process quiet, bureaucratically dense, and nearly invisible to the general public. They deliberately construct an enormous administrative obstacle course standing between you and the money the law says you are entitled to keep. You must also remain vigilant against secondary financial traps lurking just below the visible surface. The state property tax system collides violently with the federal tax code in ways that compound damage dramatically. When aging homeowners can no longer sustain escalating property tax payments, they frequently sell their longtime family homes to downsize and escape the county assessor. This understandable decision triggers an immediate chain reaction of severe federal consequences described in IRS Publication 523. Under 26 U.S. Code Section 121, A married couple filing jointly can legally shield up to $500,000 of capital gains from the sale of their primary residence. But when your spouse passes away, the Internal Revenue Service activates a strict and unforgiving 2-year countdown. You have exactly 2 years from the precise date of your spouse's death to complete the sale and claim the full $500,000 exclusion. If you wait 2 years and 1 single day, your exclusion drops instantly to $250,000. If the county hits you with a massive unfrozen tax bill in year 3 and you are forced to sell simply to survive, you face an unavoidable federal tax hit. That artificial income spike immediately triggers the devastating Medicare income-related monthly adjustment amount, known as IRMAA. Your Medicare Part B premiums skyrocket based entirely on that single real estate transaction. Your Part D prescription premiums simultaneously climb. You lost your local exemption because paperwork was never filed. You lost your federal capital gains exclusion because you missed the 2-year window. And you triggered a significant Medicare surcharge, draining your monthly cash flow for years. This is precisely how the interconnected system bleeds your finances dry through 3 entirely separate channels simultaneously. Every domino falls because you did not submit one single piece of paper to the county appraisal office when you reached the qualifying age. You are going to put a permanent stop to this. You will complete these 5 specific steps during the current week. Step 1 must happen today. Open your browser and search for your local county property tax appraisal portal. Enter your exact home address and examine your official property record carefully. Locate the section labeled Exemptions. If you have passed the legally qualifying age and do not see senior, over 65, or age 65 freeze clearly reflected on that page, you are losing money every single day. This verification check takes 5 minutes and costs absolutely nothing. Step 2 requires physical paper. Identify the specific form your state requires. Texas residents urgently need Form 50-114. New York residents specifically need Form RP-467. Washington state residents require the Senior Citizen and People with Disabilities Exemption application. Print the physical document and complete every field in blue ink. Do not rely on county web portals that frequently lose digital submissions. Step 3 demands thorough documentation. Gather a clearly legible copy of your current state-issued driver's license with the residential address matching the property address exactly. A post office box will result in immediate rejection on a technicality. If your spouse recently passed away, obtain a certified copy of the official death certificate bearing the raised official seal from the state registrar. A standard photocopy is not acceptable. Step 4 secures your legal trust position. If your property sits inside a living trust, retrieve the original trust document and verify immediately that it explicitly establishes your present legal right to occupy the home for the remainder of your life. That specific language is exactly what the county requires under the applicable statute. If it is missing, contact your estate attorney immediately and request an expedited amendment. Step 5 delivers your completed defense in person. Drive directly to the county tax assessor's office. Walk to the front counter and hand the physical paperwork to the clerk. Ask the clerk to stamp your personal copy with the current date and the word received. File that stamped copy securely at home. If the county ever claims your application was never received, you produce the stamped copy and legally compel them to honor the law. These 5 steps require no more than a single afternoon to complete. That one afternoon permanently secures your fundamental legal right to remain in your own home for the rest of your life. The rules of this financial system are written in plain view for anyone willing to seek them out, but they are deliberately composed in dense bureaucratic language engineered to make you look away. I dedicate my time to reading and interpreting that language so the burden does not fall on you. I do not market or sell financial products of any kind. I have no interest in a single dollar of your money. My singular purpose is to help you keep your hard-earned wealth out of the hands of government officials who contributed nothing to earning it. Next week, we are going to examine in precise detail The specific Medicaid estate recovery laws that state governments actively deploy to legally claim family homes from the surviving children of deceased residents. You need to understand exactly how that frightening legal mechanism functions before you or your spouse ever walk through the entrance of a long-term care facility. Subscribe to this channel if you value honest and unfiltered information. Leave your state in the comments below, and I will personally identify the specific statutory tax traps currently active in your jurisdiction. Protect your home, because absolutely nobody else in this system will do it for you. The information presented in this broadcast is intended strictly for educational purposes and does not constitute formal legal or tax advice.